Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
All right, welcome to another installment of the Just Verdicts podcast. Today, we have a return guest, which is always awesome, Tom Bosworth. And Tom is joining us today with his clearly superstar associate, Ben Phelps, to talk about an awesome verdict that they got in a van rollover case. The caption was Brown versus Global Solutions. So, guys, thanks for joining me on the show today.
Thanks, Brendan.
Thank you.
So let's talk. I mean, people already know Tom. He's been on before to talk about another big verdict that he got. Great to have you back, Tom.
Thanks, Brendan.
Yeah, absolutely. But Ben, tell us a little bit about yourself. Kind of an interesting, I don't know, we call it a meteoric rise from starting and getting to jump into a trial like this. So tell us a bit about your background and how long you've been working with Tom.
Absolutely. So I graduated from law school in May of this year from Regent Law School, which is a small private school in Virginia. I actually started working for Tom at the end of my 2L year. And I saw Tom's TikToks, I saw his Instagram, and that's how I started following him. And I started working for him in May of 2023. And continued through the school year of my 3L year in law school, and then graduated, took the bar in July of 2024 in Pennsylvania, and just passed in October. So excited to continue working as an associate at the firm, and it's been a great experience so far.
So I have to tell you, I mean, we haven't talked about the verdict yet, but I guess I'm jealous of you because, my first, 10, 12 trials I tried were just like absolute beat down defense verdicts. And, I think it's an amazing trial that you got to be a part of and you got to try it with a great trial lawyer like Tom. So, I mean, just from your vantage point, and I don't even know how you would convey this. What is it like being, a brand new, just started practicing lawyer, and then you get pulled into this trial? I mean, from your vantage point, is it now just like, oh, this is what it's like, or is it different?
It's been absolutely incredible. There's a lot thrown at me, obviously, with these types of big cases. There's a lot of pressure, but I absolutely love it. Like, I couldn't imagine not having these experiences, the opportunity to work on these briefs, to get this experience firsthand. And I'm really grateful to Tom, who's not afraid to delegate and give me tasks and responsibility and ask me to step up to the plate. And I'm just really grateful for those experiences. I know not everyone has them, and just humbled and to have that opportunity in the first place.
Yeah,
but it's been great. I love it.
Good for you, man. Like I said, I was giving your associate some advice before we signed on, Tom. Try not to let the highs get too high and the lows get too low. Emotional modulation, kind of a key to longevity in this business, I think.
Well, I told Ben, and I think he's experienced it now, that the post trial, whether you win or lose, that post trial crash, that post trial hangover that all trial lawyers know, where because you're so amped and you got all that adrenaline and cortisol that. But we tried this case. I think we tried it in a day and a half, 2 days. We put our case on pretty quick, but still, I think after me and Ben joked about taking time off, and then I went in at 8 a.m. the next day. He was there already.
But I think that can be actually the best, medicine for that hangover is just forcing yourself to get back into it rather than, trying to get the high of it all and that intoxicating effect to sort of persist is where I think we get in trouble and get in ruts and so forth. So, so Tom, tell me a little bit about, the background of this case. I know there was news articles, it was this horrible, van crash, but, put a little more meat on the bone for us.
Yeah, this was a case where a staffing company was driving people to and from a potato chip factory in Chester County, Pennsylvania, which is for those that don't know, about an hour west of Philadelphia. And these were folks who lived in Philadelphia who had a tough time finding, normal job, didn't have licenses or didn't have cars, and, were working under the table. for lack of a better way of putting it, at this factory. But the staffing company was this very, very small family-owned business. It was owned by this family in Philadelphia whose uncle, one of the uncles, was the driver. And this guy should not have ever been the driver. He had a number of guilty pleas for summary offenses related to driving from before when they let him drive, and then after he started driving, there were a ton of incidents of him speeding, going off the road, things that were scaring passengers, and that people reported to this company. And so they never did anything about him. They never disciplined him or investigated him. And then lo and behold, October 2019, he's driving 10 or so passengers to the factory. There's a torrential downpour. He's speeding, and the eyewitnesses who saw it describe essentially he was in the left lane and just slowly drove right off the road on the right side, just crossed over, hit a berm on the right side, barrel rolled in the air. The van ultimately landed on its roof, ejecting multiple passengers. Multiple people died, others survived but were injured. So we were privileged enough to represent 3 of those crash victims, and we obtained a settlement against the potato chip company, who was a defendant as well because they knew about this driver as well. We were able to settle with them in 2023, but so the case we presented to the jury most recently was just against the staffing company and the driver, who, by the way, didn't show up to trial because he was in Vietnam. He had just left the country.
And probably no plans to come back at this point, I'm guessing.
I wouldn't think so. He's got a judgment against him, so he's got to deal with that.
So Global Solutions was, you referred to them as a staffing company. So they're what, essentially, were they providing the employees to HERS, or were they providing the transport of HERS employees?
Both. So they would recruit people in Philly at barbershops and whatnot, just people that needed work, and say, all right, we'll pick you up at, 6:30 in the morning at the 7-Eleven on the corner of this street and that street. And then, so this driver, Gong Thatch, would go pick up people, and then they would ship them back and forth. But he was doing like repeat trips from Philadelphia to Chester County and back all day long.
Had any of the, the workers that were injured or killed in this crash worked for the potato chip company for a long time, or were these people that, maybe, couple here, couple there, were they consistent workers?
It was a mixed bag. So in the case of one of our clients, which is really tragic, she started working there like the week before. So that's just bad luck, or, and, but for Nathan Royal, who was a gentleman who died in the crash, his mother's Cynthia, and she was a plaintiff. He was there for 10 months, I think, and he was really turning his life around and loved working at HERS and loved his job. And he was someone who had struggled in life. He hadn't had any silver spoons, and he hadn't had a perfect pathway. But this job, in a sense, kind of like reinvigorated him, and it really gave him purpose. So, kind of a mixed bag.
So, guys, talk to me about why did this case have to be tried, as opposed to, why couldn't you get this case, like you did other portions of it, settled in lieu of trial?
Ben?
Yeah, I mean, just frank evading responsibility, I think, was the bottom line. From the very beginning, I mean, I was working on this case as an intern with Tom in July of 2023, and throughout the entire process, this staffing company just refused to accept responsibility from it. And it's really tragic, and because, at one point, we were supposed to have a trial date in July of 2023, over a year ago. But a day before trial, the staffing company filed for bankruptcy, which in Pennsylvania triggered an automatic stay of the lawsuit so we couldn't proceed against them. So that's just one example, but throughout that entire process, even through this trial in October, I mean, they still refused to accept responsibility.
And then they, of course, filed a declaratory judgment action that's still pending. The insurance company for the staffing company, which every other plaintiff lawyer involved in this case gave up on, but it just rubbed me the wrong way, because the whole issue is that the insurance company is arguing they don't have to provide coverage for any of this, because in the insurance policy they sold to the staffing company, it contains an auto exclusion. So it excludes any incident arising out of an automobile, and which is insane, because the only thing that this company did was drive people in automobiles.
Right. It's like, what's the point of the insurance otherwise?
Well, and then in the declaratory judgment action, the staffing company owner, who's a defendant in our case, sued the insurance company and essentially alleged that they fraudulently induced him and buried this exclusion in the policy and told him to his face, "Yeah, we got your back. That, you know, this insurance will cover anything you need it to." And now they're, classic insurance company move. They're talking out of both sides of their mouth and now trying to invoke this thing in fine print, which I think is unconscionable, both procedurally and substantively, but also just we have a whole set of claims against the insurance company on behalf of our clients in federal court, for punitive damages, for breach of contract, for fraud, as third-party beneficiaries, which to my knowledge hasn't been pushed by anyone, but it just never made sense to me. It's like if you're a doctor and you go buy an insurance policy and then they go, "Doc, we got you. Don't worry, this thing covers everything except for medical malpractice." It's like literally, that's literally what the case comes down to. And we have a very, very intelligent judge in federal court, Judge John Young, who we're grateful to be before. And it's these, I think some would call ancillary issues that as plaintiffs lawyers you encounter all the time. And we all know that insurance companies are the primary drivers behind unfair decision making and failure to settle cases. But in this case, Ben and I, like he said, we both were like, "Yeah, we're not putting up with this."
Well, and I think a lot of times those, reckless or callous decisions by the insurance companies it's kind of good luck for us, because it allows us sometimes to get to try, compelling, great cases where we could potentially, get a terrific verdict for our clients. So it's a weird reverse luck that happens sometimes. So in my experience, when the hammer of bankruptcy comes down, in order to, get the case back on track, you usually have to, make some type of an agreement that, hey, we'll only, look to insurance proceeds. And I'm guessing if they're filing for bankruptcy, probably Global Solutions didn't even have all that much assets or didn't have a lot going on at that point. To the extent you can, I mean, is that what you wind up having to do in order to be able to get back on track to try this case?
Yes, but nobody would agree with us. So we reached out to the insurance company lawyer and to Global, and we said, "Look, we will limit our recovery against Global to whatever available insurance there is. Will you stipulate to this?" Because I've had that in other cases, and where they have, the defense has stipulated, and they've said, "Oh, okay, as long as it won't affect, you're not going to go after the actual company or their assets, cool." Not this case. We got opposition out the wazoo from everybody. So I found myself before the chief judge of the United States bankruptcy court for the Middle District of Pennsylvania. And I've never been in bankruptcy court. Judge Van Eck, excellent judge. But, I found myself there arguing the motion to lift the stay. And I was opposed by, it felt like every lawyer in the world. I mean, they were all there. They just didn't want this case to be in a courtroom at all.
What was their rationale for why, if you're proposing to stipulate just to the insurance, that it shouldn't get lifted for your case?
Their rationale was, "Judge, why don't you just make Tom Bosworth tell us how much..." I don't know if you hear those sirens, but
yeah,
I apologize.
It's all good.
That's what you get for
don't worry about
office
it.
in Broad Street in Philly.
It's very authentic, Tom.
No, the insurance company gave us an offer. I'm using air quotes because it wasn't a real offer. And their quote offer was, we will agree that if you win the declaratory judgment action in federal court, which doesn't even have a scheduling order out, like who knows how long that would take, we will give you the $6 million if and when that happens, 4 years from now. And we were like, no, you can pay us it was 6 million total coverage. Pay it now, or we're going to go to trial. So they basically tried to villainize me to the bankruptcy judge by saying, oh, well, we offered this wonderful offer to Mr. Bosworth to hypothetically, based on numerous contingencies that haven't yet happened, potentially maybe in the future pay him, and he won't accept the offer. And so that wasn't persuasive to the judge, and it certainly wasn't persuasive to our trial judge in Philadelphia, who straight up told them that's not an offer, that's not a real offer, that's an empty offer. So, but they, that was their game plan.
So you finally get out, at least to some extent, of bankruptcy, and you get the case relisted. Obviously, nothing's changed as far as their position of no one's going to settle with you. So this is a must-try case. So from your vantage point, guys, going in, and Ben, I want to hear from you first with your sort of brand new perspective on trial work. What did you think were the strengths and weaknesses of the case? And I'll say from my vantage point, on first blush, and I always find out, and you always know as a trial lawyer that it's never so simple, but it looks like, hey, big van crash, clear negligence, big damages, slam dunk. But then the little bit I read, not so much. So tell me about what were some of the big picture issues that you were concerned about going into this trial.
Sure. I mean, from on one standpoint, I thought we had a pretty strong case of liability. I thought liability was clear. For at least the cause of the car crash, the deviation from the standard of care, all that was pretty straightforward. What we really were concerned about leading up to the trial was the damages and how to present those in a persuasive way to the jury, because one strategic decision, and I'm sure Tom will get to in a second, is our decision not to present any expert testimony with respect to economic damages at trial from an expert witness. And so that was something strategic we did in a way to present this to a jury in a way that came across persuasive. And so that was something we were wrestling with beforehand and ultimately had to make a final call on. But ultimately, I think it was a very strong decision that led to the result we were able to secure for these clients.
And I think I read something too, Tom, that, and we can kind of break these into pieces because I'd like to hear your thought processes of how you approach this and why you did what you did. But did I also read that you did not call either some or all of the plaintiffs?
Yeah, we did not call two of the three of them.
Okay. And that's highly unusual. And so I really want to know, like, how did that work out, and how did the defense not somehow compel you or call them themselves or something like that?
Yeah, I mean, so it kind of relates to what Ben just said about the day. I mean, there were issues in each of the backgrounds of each of the injured parties here for us that were really thorny issues that would have come into evidence to the extent we put on economic damages. And they would have been brought out to the jury, things about, all the things that defense lawyers love to hang their hat on whenever anyone has had less than a perfect life.
Well, because when you think about it, I mean, you're telling us these are people that are basically getting picked up at the corner by a staffing company to go do manual labor or something like that at a potato chip factory. Probably they, had a lot of hardships, were not in the best place in life, had some, tough past experiences.
Exactly. And we had economic reports for some of the plaintiffs, but the fact is, and any lawyer that's plaintiff lawyer knows that number the jury hears, it can be used as an anchor in their minds psychologically of, oh, okay, this person, we heard from the economist, this person would have made, $600,000 for the rest of their life, or $1 million for the rest of their life had they not died. Okay, the knee jerk to that is, oh, great, that's a lot of money. Well, I mean, what's the pain and suffering award going to be on that? Is this thing we struggled with? Let's say they adopt our economic numbers, even after hearing all the unsavory facts that would come along with putting that evidence on cross-examination about the criminal background and job problems and mental health history, homelessness. So like really thorny stuff. Let's just still assume we get that full number from the jury, $750,000, because these folks weren't making tons of money. They could give us another 750,000 for pain and suffering and think they did us a really good favor, 1.5 million. And so those were the things Ben and I were worried about, because we didn't have big boardable damages. And as for calling the plaintiffs, there were two issues with respect to they're separate issues. So one of our clients, Miss D, the nicest, kindest woman in the whole world. Like, despite what happened to her, she was in the front seat. She's like so optimistic, and she suffered a fracture like of her cheekbone and like a very minor fracture of a cervical vertebrae, but she never was like not walk. She's always been able to walk around, and like she never was immobile or anything. But she doesn't speak any English, and even though I don't personally hold that against her or have any prejudice toward her, the fact of the matter is when you're a trial lawyer, you have to consider that others might and that the jury might. You have to. It's not about whether that's right or wrong to have those prejudices or whether they should. It's about whether they do. So we had an interpreter for her, a Cambodian interpreter, and the interpreter was sitting next to her interpreting every word that was being said during the trial. So one decision that we made from the jump was to have Miss D sit in the back of the courtroom with the interpreter, because it would be distracting to everybody if she was at counsel table and someone was chirping in her ear. It would be distracting to the jury, and that's something I told the jury in my opening statement. I said, I said, you see Miss D over here. She has an interpreter. I don't want you to think there's anything. We don't care about her. We care about her very much, but we didn't want it to be distracting when the interpreter's interpreting for her, and you all need to hear the evidence. So, I worried that if and when we called her to the stand, there would be that prejudice about her language barrier. And then also I knew from sitting through her deposition that things do get lost in translation when you have someone who doesn't speak English. And a defense lawyer, if they're paying attention and they're careful, can do a good job at trying to create what is an innocent and trying to transform what is an innocent, maybe language barrier issue into, someone might not be credible or they're evasive, even though that's not the case. And, so we decided we had a great medical expert to talk about Miss D's injuries. And we called him and he did a great job. They gave her $4 million. She's about 70 years old. No economic damages. Like, she broke a couple bones. I'm not trying to diminish it, but she certainly wasn't the most injured in the crash. But, it was, yeah. I mean, I think that, and then the other client was going through some very acute mental health crisis at the time. His mom had been quadriplegic from the crash and had died a year and a half later, and we had filed a motion for continuance on his behalf because he couldn't even bring himself to come to the courtroom. That was denied, so he did come, but we decided just for his sake, it would not have been beneficial for him to take the stand.
And did you make some reference in that regard to, like, so-and-so is here on behalf of his mom, but you're not going to really probably hear from him because of, just how difficult this process is for him, or something to that effect?
And then in closing, he was there for closing, but he wasn't there for a lot of the testimony about his mom because of how bad it was. And I said to the jury in closing, I put my arm on his shoulder and I said, and you heard what his mother went through. And I don't need to repeat it to you, and I'd rather not because he's here right now. But they had heard it the day before, and it was extensive, and like I knew the jury was listening. They were wincing and they were uncomfortable. So I wasn't like when, the problem when you close and then you have to remind the jury about that witness you called 3 weeks ago.
Right.
It
Yeah.
wasn't, we didn't have that problem. So it worked out.
And then the third was somebody that died pretty shortly afterward or at the scene, right?
Yeah, he died almost immediately, even according to our expert, because he suffered uh, essentially his his head was crushed when the roof hit the ground, and his spinal cord went up into the base of his brain, the brain stem. And so any forensic pathologist or any lawyers who handle cases like we do know that that's like instant death when that brain stem is just eviscerated. So we didn't have much to work with there at all. I mean, even our own expert, who's a wonderful pathologist, said, yeah, I mean, he suffered maybe 2 seconds of fright when the van went off the road before he crashed, but he died immediately. So it wasn't debatable, really.
Did he have a wrongful death there or a valid one?
Yeah, he had his mother, who was in her early 70s.
Any issues with that, regarding, their, dependence, reliance on him, anything like that, given her age, and that, I don't know, was she dependent on him at all?
She was not. And because we didn't put economic damages on, we didn't get into that on her direct examination. I only asked her about what her relationship was like with her son and what he meant to her. And she shared, actually, that she had been in an abusive relationship with his father, and that she shared a memory she had of when he was 3 years old and he stood up to his own father who was abusing his mother, and that since then he's always been her angel, as she testified. And so the jury didn't hear anything about any economic or financial support, but I think they understood what he meant to her as a son.
Yeah. Ben, I want to hear from your perspective. So, I don't even know if we touched on this because we mentioned it before we got on, but you tried this case before you'd ever even, for example, taken a deposition as a trial lawyer, right?
That's correct.
That's sort of the opposite way it's supposed to go. You're supposed to take 1,000 depositions before you take your first trial.
Exactly.
I'd like to hear just from your perspective, Ben. Sitting through your first trial, was there anything about it that surprised you, was different than you expected, or was consistent, or really kind of stuck out to you?
Yeah, I think one of the biggest lessons, if I can elaborate on that I learned from this trial, was just how meticulous to detail you have to be with these types of things, and every single detail matters. And that's something Tom is really I'm really grateful to work at this firm for. Tom's been a great mentor in teaching me the practice of law. And just like every single thing has to be considered when you're putting together a direct examination. And so when I did the direct examination for Frank Costanzo, who was our one of our accident reconstructionist experts, and also another witness who was actually witnessed the van veer off the road, and putting those things together, I really, really had to pay attention to every single detail. I had to go through multiple deposition transcripts, and for me, that was a huge learning lesson. Is to be persistent and to be, extremely neurotic when it comes to those details, because they do matter. And I'll just give it a quick example. Is with, for example, the accident reconstruction, we have to make these judgment calls. One of the defenses that we were worried about was this car, whether it hydroplaned off the road because it was raining at the time of the incident, and the driver was going, according to the police report, 62 to 64 miles per hour over the speed limit. It was like a 55 mile per hour road. But the issue was, the defense was, one of their theories was that the van hydroplaned off the road. It was not the control of the driver, it was out of his control. And so we had to make that judgment call, and we were able to get the expert, through that, being aware of that defense, to basically say, look, if he was hydroplaning, he would have had to be going 84 miles per hour over the speed limit, which was inherently reckless. if he was doing that in the first place. Or alternatively, he lost control of the car because of his own negligence. And so we were able to put them in that bind in trials that they really couldn't argue that. So I thought that was just one area where I kind of learned a lesson about how to, be strategic and how to be meticulous with those details, and was grateful for that opportunity.
I have to give Ben credit, if you don't mind.
Please.
Because you hear this case, and I think you mentioned, Brendan, you said it at the beginning, like, oh, a van goes off the road in a rainstorm. It wasn't really that easy, though, because the thing is, he was going 62 in a 55. I mean, I was going way faster than that yesterday.
Yeah, that's like the standard speed limit for everybody.
And you're in Philadelphia County. I mean, nobody's gonna hear you were going 62 and a 55 and go, "Oh my God," they're just
gasp.
not, right? So, and then the driver not being at trial, initially I was psyched about, but in hindsight, I think that was a huge advantage for the defense because, number one, his deposition was so horrible and so lacking in credibility, and he changed his story 17 times, that he would have been a horrific witness. And number two, when he's not there, you kind of have this, amorphous situation where, they were in a lot of rain and he was going a little bit too fast and, he went off the road. Okay, right? But Ben did an excellent job at bringing out through the eyewitness guy who was behind the van that the driver sped past him, and through the accident reconstructionist that there's no situation other than this driver being careless where you would just go off the road. And I know Ben had to encounter the defense lawyer hubbub where they I think their whole thing wasn't, Ben was like, well, like, so it wasn't that abnormal that he changed lanes. And we had, because he went from the left lane to the right lane off the road. And Ben and I kind of were like, yeah, and that's normal to it, unless you go off the road, if you keep going.
Yeah, right.
So, but the defense lawyers kind of left out the last part where he kept going off the road.
Yeah, right. Yeah. And that's, Ben, you see those, lots of those little pieces where you can capitalize on that sort of you can't ever plan for, but you have to always be looking out for trial, these little gifts that you can kind of turn to your advantage. From your perspective in preparing, your direct with the expert and the eyewitness, one thing that struck me when I first started practicing was, I would have this whole exam laid out, and when I got actually into trial and could feel the, the moment and how it felt in there, it felt like, look, I don't have enough time to cover all this. Like these people's attention span, they don't want to listen to me go on in my entire, and so you have to shrink things down. Did you get that vibe at all of like when you're in trial, that feeling the jury's watching? It's like, come on, man, get to the point.
I got that vibe with the reconstructionist just because, to be completely frank, going through an expert laying the foundation, their qualifications to a jury, it's obviously we have to do it. We have to get on the record. But at the same time, I'm sure it bores the heck out of a jury. So, with the reconstructionist, I try to be more cognizant of that and try to keep it, short and sweet to the best I could. But conversely, with the eyewitness, he was actually somebody who was traumatized from seeing this incident. He was the first person on the scene, and I think Tom would agree with this, but I think the jury was drawn into his testimony because he witnessed bodies flown and strewn across the car, saw horrific things, and actually testified that he could not continue driving on that road for a period of time following the incident just because of how traumatized he was. So I thought the jury was engaged. I did, nevertheless, I try to keep things short and sweet just so I'm not dragging on and on. But I had to be more cognizant of that with the accident reconstructionists for sure, of just keeping their attention.
What was your overall sort of order of witnesses and proof in the case?
We had a videotape of, did we call the pathologist first?
We did.
Yeah, we called our forensic pathologist who did the cause of death on video first. And she went through the cause of death of two of the people who had died. And then we called the accident reconstructionist that Ben examined, who was also on video. And now I'm forgetting.
The next person we called was a police officer who responded to the scene of the incident, who interpreted the defendant driver's testimonies and statements to the police. He was the interpreter, so Tom called him next, and then we called the witness that I gave a direct examination for.
And then what? The one family member? Anybody, like, was there any other, before, after testimony, condition witnesses for Mrs. D or anybody else that didn't testify?
No, we did have a liability expert against the staffing company to talk about how they shouldn't have hired this guy. And one of the interesting things about that was, and another difficulty with this trial that I don't think would be apparent to everybody unless you've had to deal with this, is in this crash, the driver actually pled guilty to a summary offense for reckless driving. But lo and behold, there's a statute in Pennsylvania that clearly states that guilty pleas to summary offenses are completely inadmissible in civil trials, which can go on about how that makes zero sense for like hours.
Right.
But
Yeah.
The jury never ever heard, not one time, that this guy pled guilty to this crash, which I also think is really difficult as a plaintiff lawyer, because if I'm a juror and I'm not a lawyer and I don't know the law, what's the first thing I'm wondering when I hear this horrible crash? Oh, well, he must have gotten guilty. He's guilty, right? He went to jail, or he's some criminal. You don't know that there's a statute that prohibits the plaintiff lawyer from telling you that. So the fact that they don't get to hear it, I think, only is hurtful to us, because the only assumption that I think the juror could conclude from that is, well, they found he must not have done anything wrong. And so that was an issue. And then, of course, the two summary offenses he pled guilty to before he was hired that were unrelated to this crash itself were precluded by the trial judge under the same reasoning. But, and this is, I think I told Ben, I think the most important trait you can have as a trial lawyer is to listen closely. And like, we want to talk a lot. I'm guilty too, but like, you can't know what to say if you do not listen to everything. And the defense lawyer for the staffing company got up in his opening statement and looked at the jury and said, you'll hear that Gong Thatch was a great driver. He used to drive an ambulance back in Vietnam, and he had a safe driving history, period. And so I tapped Ben. I said, Ben, am I losing it, or did he just say that?
He's a great driver.
Yeah. And then so when I raised it with the trial judge before we called our liability expert as to the staffing company, because she had relied on his prior guilty pleas, and I said, Judge, before we put this witness on, we ought to be entitled to tell this jury that, contrary to Mr. Negretti's statements as defense lawyer, Mr. Gong Thatch did not have a safe driving history. I mean, he stood up and told the jury in plain terms he had a safe driving record. That's just not true. It's not true. And the only way to remedy that prejudice, which is immense, is to tell the jury the truth and allow us to tell them the truth. And I said he didn't just open the door; he blew right through it. And she said, I totally agree. And then the defense lawyer tried to deny to the judge that he said what he had said, which I had the transcript printed. When you wake up early for court during trial, and there's a couple little things you need to print. Like, that was one of them. I'm like, I gotta bring this transcript. I highly doubt this defense lawyer will, dispute he said this, because look, it's right there. But that,
Sure enough.
And then the judge lambasted him, because I read it in the record, and I had to read it twice in the record, and then the defense lawyer said, "Oh, I'm sorry," or something like. And so we got those prior incidents in, but again, the jury never knew he was held responsible for the crash itself.
Yeah. I think, Ben, I don't know if you knew that this was such a common and useful technique, but getting the daily transcripts from the trial. And when I first started trying cases, I didn't even know that was a thing. In fact, I probably tried a bunch of cases and didn't know that was a thing. And when I finally discovered it, it's just so helpful and useful when there are nuggets out there. And instead of you just trying to, summarize, oh, I think, you remember when they said this, you can literally show, that jury sometimes in closing, like, don't forget what they said right here, read it directly to them. This is from his transcript from this trial. Such an important thing. And it drives me absolutely bonkers. I've tried a couple cases recently where the court reporters were like, yeah, we can't do it. We just can't do it. And I'm
Wow.
like, I will literally pay you whatever you quote me your price and I will pay it. And they're like, nope, no, just too much. We're too busy right now. Just because it's such an effective tool. So you mentioned earlier, Tom, that I mean, you guys covered a lot of ground, but did you say you put your trial on in something like a day and a half or 2 days?
Yeah, we opened at like lunchtime on a Monday. And did we rest Tuesday afternoon, Ben?
Yes.
Yeah, we rested Tuesday at like 4 p.m. And
On a multiple plaintiff case.
yeah, and
Wow.
the judge looked at us like I called the I think our plaintiff, the mom, was the last witness, and the judge the day before, this was all in humor, of course, was saying, "Oh, you guys aren't going to be done by Wednesday," and so I like asked my last question of this poor mom who was crying her eyes out, and I sat down. I said, "Plaintiff rests." And the judge looked at me like, "Really?
What?
All right."
Yeah.
And then she was like, "Defense, do you have a witness?" And he was, "Oh, well, I have to talk to my client." And
Yeah, we're not ready. Maybe we have a
yeah,
little time,
yeah,
and I just think that looks so good on your end. You guys got to the point. You knew what you needed to prove the case. You're done. Now defense gets up. They're kind of, oh, we have to think about this, and we weren't expecting them to be done so quickly. I mean that's amazing to get that case in with three different plaintiffs and catastrophic injuries in a case like that in a day and a half, including openings, both of the openings. So, what was the defense approach, and then roll us into the closings.
well, uh, the defense approach was, which I think I told the jury this in closing. I said, when you don't, I call it the 3 Ds. When you don't have a defense, what do? You distract and you downplay. And so they spent 85% of their time with the jury during the case talking about whether when the van hit the berm, whether it rolled clockwise or counterclockwise, and was it 2 seconds that the van was in the air before it crashed, or was it 1.73 seconds, or what? I mean, really, they spent the majority of their time. I mean, am I wrong, Ben? And it was,
That was
and then also talking about how gently this driver drove off the road. I mean, how calmly the van veered off the road. And so I told that to the jury, the 3 Ds, and I said, so I don't know if this is verbatim, I don't remember, but I said, I mean, do you all remember them talking about counterclockwise, clockwise, upside? Who cares? Seriously, who cares? These folks were in the van in terror, rolling through the air before they came crushing to the ground, some of whom died and others who were thrown out of the van. Who cares if it was rolling counterclockwise? You think they were thinking about that when they were in the air? And I was getting a lot of nods. I mean, it was one of those, I didn't have to beat a dead horse, but it was, and then, the defense lawyer for the driver got up and said, I really don't want to do this, but Mr. Royal, he really didn't suffer because you heard it was just 2 seconds that he would have been aware that the van was. I'm sorry, I really don't want to do this, but basically like
Yeah,
implying
right.
that it wasn't.
Big deal.
Yeah, and so in rebuttal, I said, "Do you remember when Mr. I said his name got up here and told you was basically no big deal what Mr. Royal went through, and he didn't want to do that?" Yes, he did. Yes, he did want to. He did want to because he wants to drive down what you're going to what you're going to find he went through and what he suffered. He wants to take that number, dollars, that's what he did it for, and bring it down. Why else would he have talked about that with you? And so it was, I think they knew they had a tough time on liability, but I will say that they did not make the same catastrophic mistake I see a lot of defense lawyers make in a case like this, which is to fight every single detail and to really get into the nitty gritty. I will give them credit that I think the verdict would have maybe been a lot higher had they done that, but I don't think they enraged the jury. They really got up in openings and in closings and said, look, we get it. This is horrible. It's a really bad situation. They didn't cross the mom we called at all. They didn't cross our medical expert on the lady who was quadriplegic. Like, they did make some what I thought were intelligent decisions, which kind of annoyed me because I love when the defense lawyers do their rote blueprint where they just think like, you know, we're going to fight everything. And so
Yeah.
Ben and I talk, and one of the things I think I told him was, whether on the plaintiff or defense side, I think one of the most valuable things as a trial lawyer is understanding the difference between can I do something versus should I do it. And I'm not always perfect at that. But I think like a lot of times we, like as law school and as lawyers, we learn, oh yeah, you can do all this. Think, wait a minute, should we do that? So I do think the defense like was able to kind of dilute the rage factor by conceding like a lot of points.
Yeah, I mean, I think we've certainly come to see that there's different ways that juries can get ticked off, and a lot of it can just be by how the opposing lawyers respond to the case, and yeah, going scorched earth oftentimes is ideal for us, and yeah, you don't oftentimes see defense lawyers be so strategic as to think about, well, look, we've just really got to just kind of concede this because otherwise it's going to backfire even further. So yeah, I could see how that's somewhat frustrating in a case like this where if they really step in it, it could be a multiplier. So how any other aspects of of your closing that you think are noteworthy? And then I have one other. I did want, actually, let me, before we get there, I did want to ask you more about, and I think maybe you sort of already answered this. So when you don't call two of the plaintiffs, was that another good strategic decision by the defense? Because the defense could have probably compelled them if they wanted to, right? I mean, in some weird way. But I guess under the circumstances, it's almost impossible for to do that because it would have backfired for them.
Well, yeah, and I as you say that, I think I recall the defense tried to point that out in closing. They said, you didn't hear from Miss D, the woman the jury gave $4 million who didn't even testify. You didn't hear from Miss D. She was in the front seat. You never heard from her. Think about that. You just heard from her doctor. You never heard from Mr. Hewitt. And so I think in rebuttal, I got up and I said, she's been through enough. She's been through enough. And guess what? She's right there. And if they wanted to call her, put her on the witness stand and tell you all something about how the crash happened that was favorable for the defense, they could have. They didn't because they don't have anything good to say. They do not have a defense. She's right there. And I pointed to the judge. The judge would have let them call her. They can't tell you anything other. They didn't because they don't have anything to say to you. She's been through enough. And then I explained that my client whose mom had died, I think it was implicitly understood that he was visibly unwell during the trial, and so I didn't have to say much on that. But yeah, like ordinarily, I would not call plaintiffs, right? Like that's just not, I think in almost every case, your damages hinge almost exclusively on the plaintiff's testimony, but in this case, it just made sense given the circumstance, which is, again, I think, as trial lawyers, I think we are obligated to think outside the box and not just react in like a knee-jerk way to what we've what other people might do or what we've done before. I think you just have to look at your case with a completely fresh lens. And that was helpful with Ben and I together, because when you have a partner you're doing it with, they'll point stuff out to you that you're like, oh man, that's, like blind spots. So I think it's helpful to have a team.
How did you, if at all, approach, were there any specific, arguments you used or suggestions you used to help the jury understand how to think about, an amount of money to compensate these people for what, they lost in the way of their family members, or, Miss D, what she had to experience and went through in her injuries?
Well, we'll probably be reading a Superior Court opinion on whether this is okay or not. But one of the things I said to the jury in closing, because in Pennsylvania, of course, you can't suggest a number.
Right.
What you can do, and what has been held appropriate by the Superior Court, is to use the tip of the iceberg analogy. So, having that triangle and drawing a line horizontally at the tip of the triangle to show to the jury, this tip here is the economic damages that you heard about, the lost wages, but everything beneath here, beneath the surface, that's the non-economic harm. These money damages are just the tip of the iceberg in terms of what was taken from this person in what they suffered. So that's been ruled to be okay. And I said I didn't do that, but what I did say to the jury was, you're going to have to go back there and figure out what amount of money makes sense, and that's your job, not ours. We can't suggest a number to you, but I am confident in telling you, and you were here to hear it, that in terms of the severity of what every person here went through, there better be plenty of commas and there better be plenty of zeros. And they did not object. I think I said it again. And I got some nods. And then, of course, I think it was even after the defense closing, the defense lawyer, Your Honor, can we see you?
Right.
By the way, if you're taking notes, waived, that's waived. If you're in Pennsylvania, you have to object at the time. But they objected, and the judge said something to the effect of, well, I heard him, but first of all, you're late. Your objection's waived. But although I think Mr. Bosworth walked right up to the line, I don't think he crossed it.
Yeah.
Later, the judge did give a cautionary instruction on it, and basically said, you should disregard what Mr. Bosworth said because you can't suggest a number, which I think I'll probably thank her for that later, because I think it protects the verdict, and I don't think it had a meaningful negative effect on the jury. But I thought it was fair, and I thought that it communicates the level of harm in a way that's not saying the exact number.
Yeah, so it's interesting as far as so first of all, I strongly believe that and some people may disagree with me, but I think that you have to take chances at trial. You have to push the envelope, obviously, within ethical boundaries, which to be, fair and right under the circumstances. But I think, some people just want to play it safe on the plaintiff side. And I don't think that our trials always lend themselves to that, as far as, you can't. You've got to take chances. You've got to make calculated decisions and risks. And, so I commend you for doing that. But I also wonder sometimes about, when they're like, oh, yeah, we'd like a cautionary instruction. And I'm almost like, I'm sort of torn. Like, does on the one hand, our credibility get hurt at all because the jury's now hearing we're getting a little bit admonished because the judge is like, hey, disregard that thing they did, sort of suggesting it was improper. But on the other hand, they're reinforcing that thing that, hey, you remember that big number that you heard or whatever it was. I don't know how it shakes out. What's your take on that?
I agree with you. I'm in the same camp. I think it's a double-edged sword that kind of cuts both ways. I think it reminds me of the it's like an analogous thing that happens during trials, which I know you've had, Brendan, and which I think is hilarious and I love is when you ask a great question that has nothing but a terrible answer and you get a sustained objection. Right?
Right.
I could
Yeah.
care less.
Yeah.
I could care less. I mean, unless it's like happening every time and you look like you don't know what you're doing, which is different. But like, when you have that last question, that knockout punch after you've walked a witness to the edge of the cliff, I don't care. The jury knows. I know, right? And so, and then so I think it depends on the overall credibility you've communicated to the jury. I think that if you've been forthright and you've been transparent throughout the trial, which I do believe is like one of the most important things, because I think people understandably don't trust lawyers. Personal injury lawyers in particular, we have to battle stigma and stereotypes that are some justified, but much of which is just baloney that's peddled by the insurance industry to try to make us look like we're bad people. So, but I think if you've overall the jury views you as sort of the beacon of what's right and what's true, I think that you'll be okay. But I always do have that dilemma too, where I'm like,
What tell me about the deliberations, how long did they take and what was the breakdown and what was the ultimate verdict?
The deliberations were, I think, 3 hours, and they awarded 15 million total. They awarded 6 million to the Hewitt case for the woman in her 60s who had died about a year and a half after the crash. They awarded 5 million to the mother of the gentleman who died instantly in the crash, and they awarded 4 million to Miss D, who was sitting in the back of the courtroom and had the interpreter.
Gotcha. Did you, whether talking with the juries or getting any sense of things, did you, get any insight on what their rationale was for how they came up with the numbers?
No, I think they just got out of there. And
Yeah, I mean, I oftentimes find
yeah.
that. Yeah.
The one trial I had, the last when I got the Melendez verdict, the MedMal case, I remember a juror came up to me after and he asked me, and I was like so flattered. Like he was a young guy, and he said, Mr. Bosworth, I have to ask you something. I'm like, this, what's he going to ask me? Like, how did you cross-examine that witness? Or
Yeah.
how did you make that argument? And he goes, where's your watch from?
Hilarious.
Just like I love like juror stories like that, because we always like, we joke,
Yeah,
trialers joke about the things that juries pay attention to or whatever, and they're not always have anything to do. They don't always have anything to do with anything. So,
and there you go. I had a juror one time ask afterwards, like, did I think that it was a fair amount of money?
oh wow,
And I was just like, I said, look, that was what you guys came up with. So big believer in the justice system. So yeah, I think it was fair. 12 people came up with it. Who am I to disagree with it one way or the other? So thank you.
I will say we had 8 jurors. We had
Oh,
8.
interesting. Why did you guys go 8?
I think we just wanted to get the trial in and out as quickly as possible, and we wanted to kind of be punchy, and we didn't want to deal with I mean, we just kind of like the drawn out jury selection process. So
Yeah. So you get, delay damages, you're going to have appeals and all that fun stuff. But, an amazing outcome on a really tough damages case with what you described. And I think, clearly you guys made some really good strategic decisions. Anything you think in hindsight you would do differently? I mean, it's hard to argue with a $15 million verdict, but anything you said, oh, we would have been even quicker, would have done this, would have done that? Probably not.
Ben.
Ben's going to say, absolutely not, Tom. Everything we did was perfect.
That's unfair for me to punt that to Ben.
It was perfect.
Smart, Ben. Very wise.
No, I do think we did the best with what we. One thing I thought about after was like, should I have tried to get in the driver's deposition testimony because it was so bad for them? Maybe, but then again, that's just kind of goofy when he's not there. That I don't know that the jury would have understood that. I don't know that I would have been able to kind of like emphasize the importance of that without a person there. But that's something I've thought about.
Did you have that on video or was it just
It
transcript?
was on video.
Yeah.
And so, but I kind of landed on the conclusion that I liked the optics of him just not being there and being out of the country. So
Yeah, absolutely. Well, Tom Bosworth, Ben Phelps of Bosworth Law, really appreciate you guys doing this. Tom, you're everywhere on social media, so it's easy for people to find you, and obviously people can go to Bosworth Law. Ben, what are you up to next? When's the next massive trial verdict you're gonna get? And have you taken a deposition yet?
I took my first deposition yesterday, actually. It's funny you mentioned that.
Congratulations.
In a med mal case.
Good
Thank
for you.
I appreciate it.
Any big plans for the future, guys?
We got a trial in January against a huge utility company in Philadelphia that shut off the electricity in the home of an 11-year-old boy who they knew had life-saving medical equipment that required electricity because mom was behind on her bill about $100 and he died.
Oh, well, that sounds horrible and pretty compelling.
So Ben's trying that one alone. I'm just kidding.
I'm here to tell you.
Team effort on that one.
Well, that's awesome, guys. I wish you the best of luck in the future and on the appeal. And thanks for doing the Just Verdicts podcast again. Ben, I'm sure you'll be back on at some point in the not too distant future. And keep up the great work, guys.
Thanks so much.
Thanks, Brendan.
You got it.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.